Hi, everyone. Joe Brock here from the Labor Relations Institute. For those few of you that I have yet to meet, um, I'm a consultant that's working with the company during this union organizing campaign, and I've met with most of the employees. What I do is I work for a company called Labor Relations Institute, and what we do at LRI encompasses all areas of the employer-employee relationship. We work with companies that have unions and have had them for decades. We work with companies that do not have unions and have no prospects of having a union. And we also work with companies like yours. There's no union there, but there might be. We consult with the management team because many times in these situations, the management team doesn't really know what this means. And we also consult with the employees. Again, I'm not an employee of Life Care Hospital. I'm someone who knows a lot about the subject matter. I'm a subject matter expert, and so my goal is not to educate you about life care. You know about life care certainly a lot more than I do. So that's not what we're here to talk about. But here's what I do know about Life Care Hospital. They're like virtually every other employer in this country. When it comes to its employees joining a union, their goal is to perhaps convince you not to do it. They'll campaign on the idea that you shouldn't do it, and that's an important word, campaign. Your employer has a lot of good, sound business reasons why they don't want this, but they are business reasons, and they do make a business decision to fight organizing drives. And it has a lot to do with things like the value of the business and flexibility and competition and everything else surrounding why they don't want a union. And it has little to do with your pay and benefits, actually. But it is about money. The union will work hard to try to get you to vote yes in the upcoming election. For them, it's also about money and it's also a business decision. They've made a business decision to come here. If you join them, your potential customers are theirs. And if you vote yes, you'll likely eventually pay them money out of your paycheck. That's how they make money. It's not a dirty word, but that is the reality. They are in this for the money, and it's about money for them, like it's about money for you. So at the end of the day, you should do what they're doing. Make a business decision. This is a business decision for you also, and do your research and understand that both of these entities will be campaigning for your vote. And in campaigns, people don't always tell the truth, right? So my job here is to give you information, to give you what I hope you'll see as accurate information so that you can make a good business decision here. One word of caution, be careful about the rhetoric of a campaign. Both very often one side will try to get you angry at the other side, and campaigns can become filled with rhetoric, as you know from listening to the regular political campaigns. So beware of that. This is a business decision. This is your business decision. This is a purchase that you're making. Do your research and make sure you're making a good purchase. Don't vote against your employer if you're thinking, if you're going to vote for a union, do it for the right reason. Do it because you think they can help. Anyway, what we're going to talk about in this webinar is the rules of the game. We're going to give you some factual information about how this is played. We're going to talk about what happens when the union wins. And for this program, you're going to need to have this booklet, the Basic Guide to the National Labor Relations Act. It should be included somewhere in this webinar. Your employer should have provided you a link to it, and you can refer to this. You don't have to. You can look at it later. I'll be pointing out some things in there. The idea behind this is to give you accurate information. At one time, I was a truck mechanic. I used to fix trucks for a living, and for me, when someone brought me something that I didn't know how to fix, my goal was to figure out what it's supposed to do when it works, right? So if you can figure out what something is supposed to do when it does work, you can probably figure out everything that can go wrong with it. Same thing with labor law. That's what this booklet is. This is a basic guide to labor law. And this is what is in play right now. Your employer and the union are going by this guidebook. So if you understand a little bit about how labor law works, you can pretty much answer your own questions as far as what could go right and what could go wrong. So that's our objectives today. We're going to highlight some basics of labor law so you just understand how this process works. Hopefully, we can encourage questions and dialogue. You'll be able to hopefully seek me out in the workplace or email me within the next couple of weeks before the vote. And the idea is to cut through the rhetoric and provide factual information on this process. So, who do you believe in this process? The National Labor Relations Act was an act of Congress in 1935. It was written by lawyers and legislators in 1935. So, if I were to provide you with the full version of the act, it would be daunting. It's a difficult read. So the National Labor Relations Board, which is the government agency that enforces the law, dumbs it down for us so that dumb truck mechanics like me can understand how labor law works and what their rights are. So this law governs both sides. The National Labor Relations Board is the government agency that's going to run your election, and they do a pretty damn good job of it too. It's a secret ballot election that you're going to have on February 25th and 27th. Nobody can cheat. Nobody will know how you vote. So they're a real good source of information. And before I actually even get into this, on the very back page of this, if I say something, or the union or the company says something that you're not sure about, you can actually call one of the numbers in the back of this book and ask for the officer of the day. You're in Region 4 in Philadelphia, but you can actually call any office and ask them a question, and their job is to give you a factual answer. Their job is to not try to get you to vote for the union or against it. Their job is to just tell you what the law says. So you can call them and ask them a question, and they'll give you good, accurate information. They're government employees, so they have the time for you, and you can call them and ask them your question, and that's a real good neutral source of information about unions. So let's get into it. If you were able to look at page 3, paragraph 2, I spent a lot of years as a union organizer. I was actually the president of my union, a large Philadelphia area Teamsters local. So, and I've negotiated hundreds of collective bargaining agreements and have organized hundreds of employees. As a former organizer, I know that the employer's not going to let me in the building, right? They're not going to let me come in and just organize you. No employer does. So I've got to get some employees in the workplace to exercise their Section 7 rights. And your Section 7 rights under labor law says that if you think the union is a good idea and you think you would like to see a union get in here, you have the right to help the union get in there. You have a right to lobby for the union. You have a right to try to get authorization cards signed. You have a right to try to get people to vote yes. You can form a vote yes committee or an internal organizing committee if you want. And I see some employees in this workplace enforcing their Section 7 rights, and there's nothing wrong with that. The employer cannot discipline you in any way, shape, or form for exercising your right to support a union. But Section 7 also says you have a right to refrain. And what that has come to mean is that it doesn't mean you just sit back and let bad things happen if you think this is a bad thing. It means that if you do think this is a bad thing, you have every much a right as those that think it's a good thing to lobby against it and to refrain and to try to get people to vote no and get people to not sign a card. You have a right to form a vote no committee if you want. And I see that in this workplace, people are also exercising their Section 7 rights in this regard also. Those are both your rights. One qualifier to that, you need to do your lobbying or when you're exercising your Section 7 rights, you need to do it in non-work time and non-work places. Breaks, lunchroom, before and after work, places like that. You can't be doing it on the floor or you could be subject to discipline. Just like you couldn't sell Girl Scout cookies when you're supposed to be working on the floor and taking care of your patients. But any other times, non-work time, non-work place, breaks and lunch, you absolutely have a right to exercise your Section 7 rights. So those are your Section 7 rights, and your employer can't impinge upon them. How do you do it? Now, the union, in this case, 1199C, cannot just call the labor board and say, hey, those employees in Westchester need a union, we want to have an election. The labor board wants to know that there's some interest in the workplace. So that's what the authorization cards are used in this purpose. Authorization cards can have many other purposes also, but for purposes of here, they've used them to gauge interest, and they've gone and taken those cards to the labor board to get an election. The labor board wants to know that there's enough support in that workplace for them to come down and sponsor an election. Um, Now, those authorization cards, and I won't get as deep into this as normally I would. There's a lot more potential meaning to that, but you know what? We've got a date scheduled. For sake of brevity, I'll let you know that the information that you filed on those authorization cards are used in this case to garner an election, and that's what's happened here. What is that number? The unions must have that showing of interest, and on page 8, paragraph 7 of the guide, it says that number is 30%. If the union is able to get 30% of the employees in the bargaining unit that they're requesting to sign authorization cards, the labor board will consider that sufficient showing of interest to have an election. Okay, and that's what's happened here. The voting process is already agreed upon. It's going to be February 25th and 27th. You can vote either of those days, 6:30 to 9:30 a.m. The voting location is in the area where the employees have been meeting with me in the annex, right adjacent to the lobby. The National Labor Relations Board is going to run this election. It's a secret ballot election. No one will know how you vote unless you tell them. Page 10, paragraph 1 outlines who wins and how they win. And it's the majority of those that vote will determine the outcome. In other words, if only 10 of you vote and six people vote for the union, all of you will be represented by the union. So it's important that the outcome is the majority, the will of the masses, as it were. It's not really representative of the will of the people if only 10 people vote. But if everybody votes, nobody can complain about the outcome. So it's important that you do your research and make a decision, and it's important that you make sure you vote, because whether you want this or not, or whether you even care or not, this will affect you. This is an important decision, and I'll even argue it's even more important than who you choose to be the president of the United States, because for you, this is going to affect your personal life much more, much deeper than that election probably will. So get involved, do your research, and make a determination how you want to vote. And make sure you vote, because this will change your working conditions most likely, and it will be money out of your pay also. Probably the most important thing I can teach you is on page 6, paragraph 2 of this. What exactly does the union win? And it's probably forgive me, but it's probably the only time I'll read to you from this, but it's important enough that you know. I'll read to you what it says, and then I'll kind of paraphrase it a little bit. When a union wins, they kind of scoop up the chips, right? They win the right to represent everyone, and they're now your exclusive representative. They get to engage in what's known as the collective bargaining process. Now, if the union could show you something today that says, hey, if you vote yes, this is your contract, this is what you'll get, this would be easy. Unfortunately, that document doesn't exist. They would have to create one. And the union would be obligated, and the company, the hospital would also be obligated to deal exclusively with the union, and the union would be your representative. So how does that collective bargaining process work? I'll read it to you. Collective bargaining is defined in the Act. It requires an employer and the representative of its employees, that's the union, to meet at reasonable times, to confer in good faith about certain matters, and to put into writing any agreements reached if requested by the party. The parties must confer in good faith with respect to wages, hours, and other terms and conditions of employment. These obligations are imposed equally on the employer and the union. It's an unfair labor practice for either party to refuse to bargain collectively with the other. Here's the most important sentence. The obligation does not, however, compel either party to agree to a proposal by the other, nor does it require either party to make a concession to the other. So here's what that means. The union wins. They scoop up the chips. The chips that they scoop up are your current wages and benefits. And they now speak for you with respect to those wages and benefits. And your employer and the union are going to try to get together and come up with a contract of employment for everyone in the bargaining unit. Now, your employer is obligated under the law, because that's what I just read, they're obligated to meet with the union at reasonable time and place. When the union makes proposals for changes, the hospital is obligated to consider those changes. They whatever agreements they make with the union, they're obligated under the law to write it down. Right? We hereby agree. Blah blah blah. It's not a one-way negotiation in this process. The company's entitled to make proposals of its own, and they can offer less wages and less benefits. And the union, under the law, is obligated to consider those changes too that the company proposes and write down those changes. Now, the problem in this process, and I always thought it was unfair when I was with the union, the problem is that neither side actually has to say yes. They have to show up, they have to bargain in good faith, they have to consider proposals, but they never have to say yes. Neither side has to say yes. And in this process, that's kind of a problem for the union. Because when we negotiate with someone, the reality is that both sides have to have something the other one wants, right? When you go to negotiate to buy a car, for example, or a house, both sides have a reason to want to reach an agreement. Both sides have something that the other one wants. Nobody made you go to a car dealership to buy a car. You go there because they have a car that you want. And the car dealer is not obligated by law to negotiate with you for a price. But they want to, because you've got something that they want, don't you? You have money or credit or a trade-in. In this process, the union wants to get a deal because, as they've told you correctly, you won't pay them any dues till they get a deal. So they're very motivated to get a deal. That's how they make their money. They don't make any money unless they get a deal from the company. So they're going to negotiate hard to get a deal. But the problem is the hospital. The hospital's there, and in case you haven't figured it out, they don't want the union. They're going to negotiate in good faith, but the problem is the union doesn't have anything for the hospital, right? They've got nothing that the hospital wants. They don't have patients. If they had a whole bunch of patients, then the hospital would have something to negotiate for. They don't have money for the hospital. They're in a very poor bargaining position when it comes to the hospital, because the hospital, again, they really don't want the union representing the employees. So your question for the organizer in this process is, what if the company says no? The reality of collective bargaining is, at the end, if you get a contract, and that's not automatic, if you have one, it might be better wages and better benefits. And that's great if that happens. But the truth is, it might be the same wages and benefits that you've always had, and it might be less wages and less benefits. And the only things that are in any contract that you get are things that both sides willingly agreed to. So you need to ask the union and the organizers and the representatives what the plan is. What is the plan when the company says no? I've negotiated a lot of contracts, and first contracts are always the most difficult. They can sometimes take years, and during that period of time, your wages and benefits are a status quo, and very often they're frozen. You need to ask the union about their strategy. You're reasonable people. Let's hear what their strategy is for when the hospital says no, or if the hospital says no. They may agree to a contract that increases your wages. They may agree to a contract that reduces your wages. And you may end up with the same. I'll tell you that 2 out of 3 of those are bad for you, because under all of those scenarios, you will pay dues to the union. You will pay dues to the union. So find out the union strategy, cut through the rhetoric, and hear what they have to say to see if they've got something that interests you there. So I keep using the term exclusive representation. What exactly does that mean? Now today, you have what's called a direct relationship. And unions today represent 6.6% in the private sector employees. So that means 93.4, if my math is correct, 93.4% of working people work the same way you do in the private sector. They have what's called a direct relationship. And when you have a direct relationship, all of your wages, benefits, working conditions flow directly between you and your employer. And discipline, direction, pay, benefits, your questions, everything goes to your employer, your HR department, your supervisor, and it goes back to you. That's how it works in most of the country. Now, when you choose a union to become your exclusive representative, um, the reality is that now becomes illegal, right? That's called direct dealing. You can't do it. It's an unfair labor practice. Your employer must deal exclusively through the union, they cannot deal directly with you. It's called an unfair labor practice. So your issues, your wages, your benefits flow to the union. The union goes to the employer, and whatever deal they reach together goes back through you. So forgetting how the direct relationship works here, it's important. And believe me, in every workplace, the direct relationship is not a perfect system, right? If you didn't have any workplace problems in your workplace, you'd be the only place ever. Every workplace has them, union or not. So we know what the problems are here, but you need to while that needs to be addressed, you need to understand how this process works, how the union works, and who your exclusive representative is. Let's read what the NLRB has said about exclusive representation. The Act, which is that book we're reading from, grants to the majority representative, that's the union, the power to act as the exclusive bargaining agent for all employees in a bargaining unit. Individual employees have no separate negotiating rights. They must look exclusively to the union for protection of their interests. So when it says individual employees have no separate negotiating rights, the idea of exclusive representation is exclusive of you. So make sure you understand that when you hear that the union's going to give you a voice, uh, quite the opposite. They become your voice and you lose your voice. They're your voice. They're going to speak for you. You cannot do any deals with your employer. You must go through your union. So whether you're for the union, against the union, understand that you're not going to short circuit that process. You're going to go through your union. And most of the time, at least at the first step, it's through your workplace representative, your shop steward. So make sure you understand who that will be. And if they speak well for you, then that's a good thing. But if you don't if you think that you'd speak better for yourself, then maybe you need to dig deeper into this whole idea of exclusive representation. But that's what the law says. So when I was a union organizer, I could make a lot of hay in a workplace during a campaign with these issues: respect, and kind of throw it out there that your employer doesn't respect you, and there's either too much change or not enough change, or at least poor communication of change. Um, Job security, is that an issue for you? Do you have a voice? I guarantee you one of the union flyers eventually is going to have a megaphone on there saying you'll get a voice. All of these things, while granted are important, do you deserve respect? Certainly. But when you look at what the law says, and it's on page 18, paragraph 1, it talks about mandatory subjects of bargaining. These are the subjects that the employer and the union must talk about. If the union brings up a proposal on a mandatory subject of bargaining, the company, the hospital, is obligated to consider it. When you look at these mandatory subjects of bargaining, and you look at this list here in red, you'll see that it's not on there. There are no respect clauses in a contract. I had a union that had 100 contracts plus, and while I wouldn't swear on a stack of Bibles, I'm pretty sure the word respect isn't in any of them. There's not going to be a respect clause. If I made a proposal when I was the president of the union and made a proposal for more respect, the the employer would laugh at me. There's no voice clauses in the contract either. Is there a job security clause? Well, as an organizer, I would argue that seniority was job security, and that if you had seniority, you had more job security. and I guess that's true. Um, if you have seniority, if you don't have seniority, that's not much job security, no matter how good of an employee you are. And as far as keeping a place open, no union can force some place to stay open that can't afford to stay open. So unionized places close just as often as non-union places. So recognize that while these are good subjects during a campaign and are good for driving rhetoric, they're not going to be talked about much at the collective bargaining table. The things that get talked about are things like wages and benefits. Maybe some of these things you don't like, maybe some of these things you do like. They all go up for grabs during collective bargaining. They all go on the table. While the talks are going on, nothing can change. But when talks are done and you get a contract, some of the things you like may be gone. Some of the things you like may get better. Nobody knows. Nobody knows. Imagine going into that car dealer that we keep talking about and doing a deal and signing the papers and agreeing on a price. And when all is said and done, then they drive out the car that you bought, and you don't know what the car is going to be, right? Would you do that? Maybe they drive out a Cadillac, but maybe they drive out an old Yugo or something. So recognize that you don't know how this is going to end. It may end up very well. It may end up very, very bad. But the only way it ends up is however both sides agree to. There's nothing going in there without the employer saying yes to it, and the union. So those are the mandatory subjects of bargaining. Remember, even the mandatory subjects of bargaining do not come with it an obligation to actually agree on those subjects. Both sides can say no. And that's again on page 6, paragraph 3. So at the end of the day, if anybody tells you that they know what's going to be in your contract, they're not being honest with you. However, there are some clauses that I've never seen a contract not have. And one of them is a management rights clause. Look for it. If the union shows you any of their contracts, I think they have them online. You can look at all their contracts, I believe. You can go on their website and look at their contracts. And I'm sure you'll find in every one of them a management rights clause, because companies always in a contract reserve the right to run their business. They're not going to have to ask the union, generally, in management rights clauses, about scheduling and about whether they can hire employees, lay off employees, promote, demote, transfer, recall. They don't have to ask them to set the standards. If they want to have attendance policies, generally that's a management right. They don't have to ask the union. If they want to change their rules, as long as they're reasonable, they don't have to ask the union. So, and if the hospital wants to hire some bozo to be your supervisor, they don't have to ask the union. So take a look at this. Is a typical management rights clause that I've seen in many contracts, and this one goes on for 11 bullet points. For sake of brevity, I left it at 3, but you can look at any union contract and you'll likely find that. So sorry about that. Let's talk about dues real fast. And the question is, would I have to pay dues? And most people automatically say yes, I will have to pay dues. But to that I say not so fast, because under the law, on page 3, it talks about the right of the company and the union to engage in talks and agree on a union security clause. Now, this is the second thing I've never seen a contract not have, at least in a state like Pennsylvania. A union security clause is a clause that goes into the contract that says, basically, if you want to maintain your position here, if you want to work for Life Care Hospitals, you have to basically pay a fee to the union for the right to because they represent you. Unions generally demand that kind of language in a contract. It's unlikely that the union would agree to any contract that didn't have that. I never had a contract that did not have that in there unless it was prohibited by law. And in right-to-work states, it's prohibited by law. Pennsylvania is not a right-to-work state. So these two parties can agree to that, and it's very unlikely the union would agree to a contract without a clause that says that everybody has to pay a fee to the union or they can't work here. So the problem with that is, for the union, even though they must have it, they still have to get the employer to agree to it. And the employer can say no. And it's a chip. You know, when the employer agrees to a union security clause, the union generally trades a chip for it. Don't forget what those chips are that the union's negotiating with. The only chips they're negotiating with is your current wages and benefits. That's what the chips are, and their proposals, but they don't have them. The only thing they have to trade is your current wages and benefits. So sometimes they'll trade off something you have to get something like this that's only important for the union. For me as a negotiator, I could have got, if I would bring back a contract that doubles your pay and gives you free benefits and gives you more holidays, but I didn't get a union security clause, I might get fired for that. That's how important it is to the union. They have to represent everybody. Everybody has to pay dues. That's how they feel. The next thing I've never seen a contract not have is a dues checkoff clause. If you've ever been a union, you'll know that the dues come right out of your pay. They get paid like the government gets paid, right? It comes right out of your pay. But they can only do that if they can get a dues checkoff clause in the contract. And that's a clause that says company will agree to take the dues money out of your pay and just mail a union the check. The union doesn't want to come chase you for their money. So they're very happy to negotiate something like that in a contract. But again, they've got to get the employer to agree. What would they trade to get a dues checkoff clause? They're going to trade something, the company's not giving it away. Your negotiators for the company are going to be very smart people. They're going to be attorneys who do this for a living, and they know the union has to have these clauses. So find out from the union, will you demand these things, and what would you trade away to get them? And what's your plan if the company, the hospital says no? It's important to note that in right-to-work states, union security clauses are illegal, but Pennsylvania is not a right-to-work state, so it's perfectly legal for the union to negotiate these things. Let's talk quickly about, I keep talking about what's Plan B. What's Plan B? Ask the union what's Plan B. One Plan B, and maybe the only Plan B that I know of, is the idea that we could pull your labor, withhold your labor, and have a strike. It's the union's ultimate weapon. It's the one bullet they have in the chamber. And you can read on page 4, paragraph 10, and I'll paraphrase a lot of it, and you can read it on your own. The reality is that going on strike in this country is protected. Just like, remember Section 7, you have a right to do this. You have a protected right to go on strike, and your employer can't terminate you or fire you for exercising your protected right to go on strike. Now, used to be a great weapon for unions. Back in the day, just the mere mention of a strike had employers scared, and they would give up a lot of chips to prevent a strike. When you look at those union contracts, and there's a lot of good union contracts out there, they're usually the companies that have been union for 50, 60 years and got a lot of gains back when they were willing to strike for it. It's a little bit different today, and for sake of maybe a sea change, I'll point to when we had a president named Ronald Reagan. And Ronald Reagan, back in the 80s, 80, 81, when the air traffic controllers threatened to go on strike, he threatened to fire them. And when they went on strike, he fired them. They did not enjoy a protected right to go on strike like you do today. But when he fired them, he exposed language that was always in the law, but most employers didn't dare do it, and didn't think, many employers didn't even know they had the right to do it. And that law says if your strike is economic in nature, there's two kinds of strikes: an economic strike and an unfair labor practice strike. If your strike is economic, in other words, you want better wages, benefits, working conditions, the employer still can't fire you, but they can, under the law, hire bona fide permanent replacement workers under many circumstances. And if that happens to you, you're not fired, but the problem is when the strike is over, you're not necessarily coming back to work either. The permanent replacements, if hired, if they've hired bona fide permanent replacement workers, they become the new full-time employees, and you have to wait for them through attrition to leave before you get offered your job back. Now, that was a sea change for unions, and union membership has since gone on a steep decline because the strike has no longer been and become an effective weapon for workers. It doesn't work. Employers don't fear strikes the way they used to. There are a lot more resources today for companies who have a problem with their employees going on strike, and they no longer have to worry about dealing with you if they hire bona fide permanent replacement workers. So read up on this, find out what permanent replacement means. Look up permanent in the dictionary, and that might be all you need to do. But understand that you're not fired when you engage in an economic strike, but you may not necessarily be going back to work right away either. Um, okay, we're getting toward the end here. Last slide. Um, can I get rid of the union if I don't like it? Because the union's going to tell you that yes, you can. The reality is that you probably won't. Uh, and herein lies some opportunity, by the way. Now, if you look at page 9, paragraph 1, it talks about bars to election. To bar something under the law is to prevent something, right? So once we have the election, and you can ignore the dates on this slide, but let's say your election's February 27th, and let's say the union wins. They've got 1 year. It's called an election bar. They've got a 1 year period to try to get your contract, negotiate, and as employees, the NLRB will not entertain any petition for an election. The union's got 1 year. You can't get rid of them. They're your exclusive representative. They're going to try to negotiate you a contract during that period of time. Now, once they get a contract, and if it's before that 1 year period is up, a certification bar kicks in. And for the first 3 years of the contract, you cannot decertify them, with the exception of a 30-day window exemplified here in the red parentheses, where employees can then, if they want to, try to decertify the union. That's the only period that you can. Most employees, I was a member many years, I didn't know that. Even as an officer, I didn't know about this window that opens up. So most union members don't even know that a window even opens up. And most contracts are for 3 years for this reason. The protection lasts for 3 years, and then they get a fresh 3 year protection when they piggyback on this contract. So the reality is, for many workplaces, you can always have an election to see if you want a union. You can have one every year if you want. But once you actually vote yes through this process, and because of the way the law is written, it's unlikely you'll ever have an election to see if you want to keep them. The other thing that's important to note here is that unions have rules, and as a union member, you agree to follow their rules. It says so here on page 20, paragraph 6, this last bullet point. And in those rules, you agree to do things as a union member that things like you agree you won't cross a picket line. And you also, in many constitutions, agree that you won't try to decertify your union. They word it strangely, but that's what they mean. And if you break the union's rules, they have a trial process and they can fine you money. Will it happen to you? Probably not. But if you try to cross a picket line and decertify the union, it might. It might, very well might. So understand that you give the union the power to do that through their constitution. A document, by the way, which despite my challenges, they refuse to show you what it says. It's a document that they write. It's going to bind you as a member. The union's constitution outlines all the costs, and they haven't given out one copy of it here. And so you should ask the union for a copy of their rule book so you know what the rules are, and you know what the costs are going to be, and you know what you can and can't do. So in a nutshell, that's just kind of a basic primer what you're getting into here. If you have questions, uh, please feel free to seek me out at LifeCare. I'll be there occasionally, anyway, up until the election. You can certainly email me, and I'll just spit that out. Shame on me. I should have a slide with it on there. But my email address is my name, Joe Brock, one word, JOEBROCK, at Comcast.net. You can send me an email. I'm not going to forward it to the company. I'll get you the right answer. I'm not here to lie to anybody. I want you to have accurate information, and I know accurate information during campaigns is hard to get, and I'm not here to lie to you and for the company or for the union or for anybody else. I want you to make a good business decision here, and so that means getting good, accurate information and making a decision on your own. So that's basically it. Thank you for listening. I hope I wasn't too wordy. I hope you understand the things that I've said. If not, please come and see me. Bring it with you, or I'll have a copy for you, and we can sit down and talk about it, and talk about some of the other opportunities that this actually brings about for your company. There are some good things that can happen here. So again, thank you for watching, and best of luck.